Wow. Just sign in your attendance. Hi guys.
Not yet, sir. In you future, yes, sir.
Sambil-sambil you future, yes. Sambil-sambil tu ni lah. Kita try, I don't know which one yang you all nak buat. I think kita main belasah je lah ya. I have no idea what is coming out in the exam. So this is not an indication that what question that we are doing is coming out in the exam ya. Jangan salah faham pula ya. Kita main belasah je. So, Auzubillahi minasyaitonirrajim. Bismillahirrahmanirrahim. The session, guys, is being recorded as usual. Inshallah, I will be putting it online and share the link with you. Tonight, we are going to look at the past question as many of you suggested for us to do. Like, I think last week kita buat kan? Last week kita buat apa? Soalan apa? Can someone recall? Siapa ingat? Last week apa yang kita buat? Oh, last time yang kita buat kelas malam tu.
Kita buat Q&A session, sir.
Apa?
Q&A session.
Oh, Q&A. Okay, right. Kita tak attempt past question lagi ya. I mean,
Belum.
dalam tutorial ada lah kot. Yeah, okay. For the benefit of group yang bukan under my tutorial, so tak apa, kita will do this Okay, let's look at this particular question. Can you do you want me to cut and paste and put in your what do you call it, WhatsApp? Nak tak? Easier kot. You can have a look. Sana. So this is one of the question. I capture lagi satu. Oh, where are you? In the state. Where is the other one? Oops, sorry. Ini panjang sikit. Sekejap yang baru nak masuk tu. Allah. How do you minimize this? Sekejap Yo. Tengok for the time being, the rest of you, tengok the first one yang I post dalam WhatsApp. First and the second question while I'm getting the third question screen. Alright. Okay. Semua orang boleh masuk Right. Yang duduk sini Nanti langgar jatuh pula sekali lagi. So macam mana you nampak first question? Nampak this particular question specifically identify that you are not required to explore constitutional law argument. When it comes to jurisprudence, banyak soalan that is being raised by us in the finals. The approach of students kebanyakannya straight away jawab on constitutional law knowledge that they have, because when it comes to jurisprudence, they wouldn't be able to understand in the first place, right? So they are pressured to answer. So the most likeliness that they are going to attempt is by virtue of applying the knowledge of constitutional law that they have. This is wrong, So even the question itself is indicating that you are not to explore by virtue of constitutional law argument. So instead, you have to examine jurisprudential perspective on how the problem of unjust law should be resolved. Okay, here the question is asking, frame your submission to the court with particular reference of theories of positivism and natural law. This is very clear in terms of the direction of the answer. Okay, the direction of the answer is basically talking or identifying that you are to talk about positivism and natural law, this group. So if you look at the marks, berapa markah yang you rasa pembahagian markah? You can chat if you don't like to talk. Berapa markah?
So probably 10 for positivist jurist and 10 for natural law jurist.
Very good. So 10-10 So kalau if you look at the question, 20 marks dalam non-COVID punya situation is amounting to a certain number of minutes kan. How many minutes that you have to spend for 20 marks? Kita pernah buat kan?
15 sir. 15 to 10 minutes. 15 kot.
Mana boleh 15? The whole paper is 100 marks. 100 marks equivalent to 3.15 hours. Kalau 3.15 hours equals to how many minutes? 6, 120, 180 campur 15 minit yang untuk you reading time, 195 minit untuk 100 markah. So kalau 1 markah equivalent to
2 minutes.
2 minit, 1.95 minit kan, 2 minutes. So kalau 20 markah times
3 minutes.
times 2 je lah kan.
Okay.
So kalau times 2 is equivalent to
39.
40 minutes. Okay, it is the time that you are supposed to spend for 20 minutes for the positivist and 20 minutes for naturalist. Now, markah ada, so how many juries that you are able to answer or throw in or you want to cite? Positivist? Positivist berapa orang? Guys? 2 is tak cukup. You try to put in. Okay lah, kita ambil lah kata 2 lah. Kalau kita ambil 2 ish, okay fine. So we have 4. 4 divide by 20 equals to 5 marks. So kalau ada 4, okay, there are some people yang memang fast writer, so they will be able to get 5 or 6. So kita ambil on average 4. Dia comprises of 4 juries. Kalau 4 juries dia ada 5 marks each. If 5 marks each, meaning if you present only the juries without the ability for you to show your understanding to back to the juries, you are going to get only 2 marks. So kalau lah kata you ada 4 juries, just being able to repeat back or to restate the juries of your choice in your answer sheet, so you are going to get at least 8 markah, the most 8 markah. Yeah, so you are looking at maybe 6 to 8 marks over 20. So you have failed in answering the question already. What you have to do is approach whereby you are to choose A. Can you imagine a big A in your mind right now? A big A. A is whereby you choose juries that is relevant to the question. You cannot, all this while that we have learned juries from first week until today, we have like what? 15? Yeah, 15 of them. So you cannot be able to put 15 of them in your answer. You have to choose the best 4 that is relevant to the question. So tell me, can you write down which juries that you want to put for positivist? 2 for positivist apa? On? Jeremy Bentham? Okay. John Austin and Carlson. Okay. 3 cukup for the rest, kalau at this moment or juncture of time that you are like Jeremy Bentham, siapa? Dia tu apa dia punya principle or model that dia try to produce. Austin ni macam mana? Hank Carlson ni macam mana? You are gonna be in deep trouble. Okay, so if at this juncture dah minggu ke-13 dah dekat dengan final, you are duk tertanya-tanya lagi apa konsep yang orang ni ada, you are going to be in deep trouble. This is the time yang di mana you tak boleh, you tengok nama you dah tahu dah apa dia punya model or teori or principle yang dia nak ketengahkan. Hank Carlson apa dia? Anyone? Pure theory of law. Very good. Brian. So very good. Zahira. So this is a practice for you guys, the whole of you, or all 32 or 31 of you. You must be able to be aware of the juries punya theory or concept or model that they try to put through. Now that is A. Yeah, remember I mentioned to you about A. Yeah, A is for you to be able, out of all the number of juries that we have learned, to choose only the best 4, and 2 is from positivism and 2 from natural law. Fine, done. A ya, A habis, right? Oh sorry, belum habis lagi. Natural law, siapa? John Stuart Mill, okay, right? Saint Thomas, lagi seorang? Kita letaklah siapa yang group under natural law that we can quote. Rawls, yeah, okay, good. Ada lagi? Aristotle, very good. Ronald Dawkins, yeah. Who else? Is that Islamic? Kan? The Islamic pun boleh juga kita letak lah. Okay, fine. Now you are able to differentiate between positivism and natural law in terms of their group. The next thing, this is finishing the A, the big A that I asked you to imagine in your mind. Now, we have to look into B. The B is the ability for you to recognize the problem that is being raised within the question itself. And then you are to link up B, yeah, which you already identified once you understand the question. Link up B to A. So A and B must be just like macam tangan kiri tapak tangan kiri and tapak kanan tangan kiri kanan sorry, kiri and kanan. A and B, you must be clapping them together. You must be able to link them together. If you are unable to do that, then your marks akan jadi 6/8 mungkin. Kalau Cik Nazim dia akan bagi 3/20. So be careful because the exercise that we are creating is actually the exercise to sharpen your critical or analytical punya skills. Everyone, semua orang boleh hafal, semua positivist and naturalist, but the ability for you to link them up to the problem that is given, itu yang paling penting. That is the where you are looking at 15, 16, 17 out of 20. Yeah. So there would be people yang mungkin sampai 19, 20, itu memang the one that is able to compress the argument utilizing their skills in English language, and they are able to give more than 4 juries. If they were to be able to within the same stipulated time bagi 6 say for example, then 6 relevant kalau 4 relevant, 2 tak relevant, unable to link pun tak guna juga. So kalau you dapat bagi 6 that is able for you to be thorough in your discussion of each one of them, maybe you're looking about 18, 19 or perhaps kalau perfect sangat lah, okay, I'm willing to give you full marks, but obviously kalau I bagi you full marks, other lecturers akan buka mata lah, which I don't mind actually bagi 20, right? So this is how you have to work your answer. Okay, kita nak tengok kalau perfect sangat kita boleh bagi. I have no problem giving 20. Okay, so now A and B, which one do you want to start first? Kalau kita tengok first positivist, kalau kita ambil positivist, kita nak attack siapa? So kita ambil 4 lah. Tadi somebody said Jeremy Bentham and Austin dengan Kelson. Kelson macam mana? You rasa nak which one of the three yang you nak blind? Apalah kita buat tiga-tiga lah. Let's look at Austin. Austin.
So sorry, can I clarify something? When the question states Morostriani is just a particular religious community, it doesn't mean that it's a minority, or it just means that, for example, in the
you
question,
are referring to paragraph na?
The first paragraph. when it says Morostriani is a particular religious community,
Which
does
line
it,
you're talking about?
the third line, sorry sir.
Third line, okay, constitutional amendment to deprive the particular, okay.
Particular
Community.
religious community, the Morastrian, does that mean they're a minority group in the country or not?
What do you think? When a
I
law
think
is
not.
to oppress, then the law is being created to oppress, to deprive, meaning to deprive is to oppress lah. Is it to oppress the majority or oppress the minority?
Usually for the minority.
Very good. Because takkanlah dia orang nak berani buat undang-undang yang against the majority, obviously. Kalau kita tengok South Africa, the apartheid, apart, you are to be apart from the whites. So majority of the population are blacks, but the minority is controlling the country. So they create the so-called law is to oppress the majority. It also can happen in that manner. Okay, so you have to assume. So you can assume both ways. You can say that they are people who are in power, they abuse their position in order to deprive the rights of the majority. You letaklah example, South Africa is one of their example. So kalau situation of majority oppressing the minority, mana negeri yang you boleh letak?
Germany.
Germany, okay, right. Okay, kalau you nak letak America pun boleh, towards the Indian. Kalau kita ambil Australia, towards Aborigines. Okay, up to you. Right, can we continue? Any clarification over the question? Yes, Profit. Anything?
When the question asks with particular reference to theory of positivism and natural law, can we explain based on the juris of these theories of law? Because for example, Jeremy Bentham is a positivist, but aside from being a positivist, he is also a utilitarianism. So supposedly we cannot use his view on utilitarian.
Because dia dua alam lah. Because dia dua alam kan. So you are worried nanti dia kata positivism dia utilitarian is another group, but the foundation of Bentham is about positivism.
Yes.
Okay, so kalau macam tu, if you are worried, then just leave Bentham out, then stick to those yang memang clear cut. Since kita nak buat 4, ambil 2 yang memang kita confirm ialah 3 lah. Kelson, Hart dengan Austin. So 3 is best for you to play with these 3 in order for you to link up them with positivism punya group. Boleh? Good question. Yeah, any other question to clarify? Tak ada? Okay. Kita tengok the first one, kita ambil Austin. Now, Austin kita boleh apply tak? Oh, sorry. Kita dah ambil yang tu, B dia. B, let us establish apa masalah B ni. Apa masalah the question that is being raised. Siapa boleh summarize? It is, I think it's clear cut. And the question is actually the problem of depriving those people, communities, and then resolution of the United Nations Security Council. Actually, kenapa Security Council? Security Council, dia about, tak apalah, tak punya lah. Okay, Many Moravians apply to the High Court of Shaniman to challenge this unconstitutional and lawless law that flaunts all canons of justice, decency, and legality. Okay, fine. So, macam mana yang B tu you nak relate kepada Austin? Anyone?
Can we argue that the proposed law is in contradiction with the Constitution, and the Constitution being something that is enacted and made by the sovereign, hence should be obeyed not only by the people but also the lawmakers?
So,
yeah, because I don't know how to
mention of constitutional amendment kan? Okay, fine.
Yeah.
Kalau dalam Austin ni kita nak pakai dalam dalam problem ni macam mana you rasa? Smooth sailing or a bit problematic?
A bit problematic because we are defending the rights of these people, not justifying the oppression.
And then especially we are talking about command theory that Austin is saying. Command theory comes from whom?
From the sovereign.
Sovereign. Who is the sovereign then, according to Austin?
Those who are politically superior, yeah.
Those who are able to put the law under them, right?
Yeah.
Okay, they are above the law. They are sovereign. Nothing can control them. If you are talking about parliamentary, constitutional parliamentary system, do you have that sovereign thing or sovereign concept? As compared to Saudi Arabia, as compared to Brunei, they are the absolute monarch kan? Absolute monarch. If you look at the things that the law of these two countries, they are doing things which the law doesn't have any effects towards them. They can create law, but the law does not affect them. Their family members are not going to be affected. Okay, but they seems to portray themselves as above the law. This is what Austin is saying. This particular command theory applies to current lah. Kalau dulu we are talking about during his time, kita nampak the English punya monarch. Even that pun dah goyang. There are certain countries in the world like Russia, like Persia, Persia sama. Persia, and then we have France. Okay, they have monarch, and those monarchs are in more or less total power lah. Kalau kita ambil the Islamic Empire at that point of time, we have the Ottoman. So they are seems to portray to the society that they are above the law. That position is applicable for the command theory. However, if you look at this is a situation whereby the parliament is actually being controlled by a system that is not able for them to put in the position of sovereignty as what Austin is saying. Ada tak indication yang mengatakan dia above the law? You faham tak apa dia soalan saya ni?
Sir, if let's say we argue that since this is a constitutional country, since constitution is the highest form of law, so it's considered command. So if we were to like change the command, like isn't it like okay, now I'm lost.
Tak apa, it's okay.
Okay.
It must be a person. It is not a person or a group of person.
Because of that, therefore, like the law, the constitutional amendment, because it is made to a constitution, and the constitution is not recognized by the theory of John Austin that it's not a command. Can we say that they are not supposed to follow the law, since they are not considered as a command under the opinion of Austin?
Can you interpret who are they?
They as in the
Morastrian plaintiff, right?
Okay.
Yeah. Okay, you can do that. You can apply Austin by saying that Austin's idea is like this command theory where you have sovereign. However, in this particular question, it does not reflect the sovereignty. So therefore, they don't have the absolute authority to command anyone and punish anyone for not following. So therefore, in this particular situation, the Morastrian plaintiff can ignore the laws because it does not fit in to the concept of command theory that is portrayed by Austin. Boleh? Good, very good. Guys, the rest nampak tak? The argument kita boleh twist, yeah. We don't have to really conform. Okay, this particular situation conform with this particular jurist. Therefore, I want to apply the jurist. You can go to the extent that you want to bring the jurist Austin, and obviously you know this situation is contradicting to what Austin is saying. Then you use to say to the people who are subjected to that particular command not to follow the law because it is not considered as valid law.
So sir, in a way we are criticizing these views from positivist jurists lah.
Yes, nampak tak? When you mention about the word, when you utter the word criticizing, meaning you are criticizing by virtue of the jurist or the principle that the jurist brought inside or presented. You are not coming up to criticize using your own idea, your own opinion of a situation. So nampak kat situ. Kalau you kata no, they are not right, therefore this is unjust, this is not natural, this is not universal, whereby kalau you nak pakai natural law lah, tapi we are not looking at natural law by virtue of United Nations Declaration of Human Rights, and you are going along the line of constitutional law. Habis, yeah. So gone, your argument is gone. But the moment as you are able to link it up to Austin by virtue of agreeing or disagreeing, then you are on the right track. So I think you can get about, kalau 5 markah untuk Austin, then you get 4 or 5. Especially because you dah boleh tunjuk kata you faham apa yang Austin idea. Some people make outright mistake. Dia kata sovereign, the parliament is sovereign, habis, gone. You must go against it and say that no. Austin kata sovereign mesti sovereign, or sovereign mesti above the law. In this particular situation, we are talking about constitutional punya system whereby the parties are separate. You look at the fact that they went to the court, meaning when they went to the court, there is another authority that can override the command or the law that is being created by the House of Representatives. Okay, you boleh nampak So di situ ada separation of power dekat situ. But you are not to discuss about separation of power, but you are only to discuss about Austin. So you kata this problem does not suit the sovereign in Austin, so therefore you can say you can conclude that the citizens can reject or not following the law. And if they were to go against the society or the government by nak revolt ke, nak buat coup ke, I think it's justified. Boleh guys?
Boleh sir.
Siapa yang tak nampak? Kita tak nak lah you duduk dekat dalam ni tapi you are unable to see. Siapa? Tak apa, cakap je, tak kisah. Don't worry. I'm not going to do anything to you. It's just a matter of we need to clarify things. But exam dah dekat sangat lah. Okay, good. That is habis daripada 4, 1 dah down. Second person kita nak ambil apa? Nak ambil Had ke nak ambil Kelson? Kita ambil Kelson. Yasmin seorang yang nampak, Had lain tak tahulah ke mana arahnya. Okay. Don't waste your time lah. Kalau ada kat sini you duduk tak faham, tak guna juga. I'm here to make things clear. Kalau I'm here to make you more confused, then it validate you to get off the line. Okay, next person you nak sembang berkenaan siapa?
Sir. How about Jeremy Bentham, sir?
Jeremy Bentham, as what one of you saying, dia punya group, actually dia punya group tu utilitarian, the final result. But before he reached that utilitarian as a specific group, dia adalah positivist. He agrees to the obedience of people towards a law that is being created by the government. Because though the government is doing something that is against natural punya element, dia cuma tengok on the legality or validity of the law. If the law is properly created, okay, you have to follow. Why you have to follow? Because the benefit that will be derived from following the law is going to make a majority of the society happy. Okay, itu yang the greatest happiness of the greatest number of people punya theory.
But what if we argue that even though it is bring the happiness to the majority, but it is only in the state of Shanimya, but it will make the rest of the world unhappy because it create a humanitarian crisis by denying the Morossian their national right. Can we argue it that way, sir?
We are looking at the sovereignty of the country. Itu yang bahayanya. Bila kita tengok the sovereignty of the country, meaning United Nations cannot impose towards another country dia to overrun their sovereignty. Mana boleh? You mana jadi Pak Sibuk? I know you are the Security Council. You won the war last time. Therefore, your group of winners, right? So it doesn't mean that you won the war. You have any all the authorities to dictate other countries to follow you. You belajar international law kan, sovereignty. So we don't have to go to that. But if we were to apply Jeremy Bentham talks about the law that is validly created within the country itself. It is going through the process. If it is going through the process and the process is clear, nothing hanky-panky going on, therefore the law is valid. And in order to show whether that particular law is valid or not, look at the outcome of the law. Whether the law can create greatest happiness of the greatest number of people. Pain pula. Dia kata maximize pleasure and minimize pain. Betul tak? That is the detail of the theory. So kalau you argue on that line, you kata, yeah, the law might be okay. However, the outcome of the law is going to create a situation whereby people are going to be not happy, where ada banyak pain, rather than the pleasure. Contoh kita ambil kat Malaysia, kita punya new economic policy. Back then maybe okay, but since nowadays people are starting to argue in saying that how can you have advantages to a certain group of people, whereas we have number of years that has passed. We have to look at merit as compared to group of people. So the tension is going to be there. I believe the tension is already here, between the races. It's just a matter of they don't want They realize that they don't want to create any problem because oppression number one, and civil war punya situation, nobody is going to win. Okay, kalau you tengok civil war, everyone is killing each other. So but that cannot be running away from the fact. The law is actually you know, is creating unhappiness to the society. Boleh tak ni?
Faham sir.
And the rest ada yang keliru Jeremy Bentham. You nak pakai Jeremy Bentham, you buat statement ya. You buat statement awal-awal. Kata though Jeremy Bentham might be considered as a utilitarian, you know, but by definition he might be considered as a utilitarian because his idea is slightly different, but the basis of his idea is based on positivism. Itu you kena buat statement. You have to quote, you have to protect yourself. You don't want to simply talks about Jeremy Bentham and then suddenly the examiner kata, kenapa pula bawa masuk Jeremy Bentham? Dia kan utilitarian. I want positivism. I'm looking at Austin, Hart and Kelson. Memang clear cut lah dia orang ni memang positivism. You bagi caveat. Okay, you bagi caveat and saying that yeah, I'm going to choose Jeremy Bentham, though I realize that he is not pure positivism group, but the basis of his argument is basically the foundation is actually based on positivism. Kalau you nak play that atau you want to use him lah, some people are happy with that, Lagi? Kalau Jeremy Bentham faham a raise of notes dekat kanan tu, siapa yang faham ke tak faham? Tak faham kita boleh discuss lagi sikit. Faham? Okay, good. Okay, for yang masih tak mau state, Bentham ni kita tak berapa favor because dia duduk dalam dua alam. Okay. Tapi argument dia belah kepada apa orang kata positivism. Okay, next one, Hart. I realize that you nobody's mentioned about Hart. Primary, secondary rules. It's quite straightforward. Jadi tak ada isu di situ kalau you nak pakai. Siapa yang nak boleh link B of Hart? A sekarang Hart, B dia apa? Macam mana you nak link Hart to the problem? Anyone? Tak apa, try. Jangan risau buat silap. Or should I call one by one? Aimi duduk dekat atas. Nyesal dia A. Aimi, are you here? Adnin.
Hi, sir.
Hi. So, macam mana you nak try? Hart.
Okay,
Try.
For Hart, primary and secondary, for example, in primary, if the federal constitution allows an enactment of constitutional amendment, and the Nationalist Party has fulfilled the conditions and procedures to allow a constitutional amendment, therefore the law which kind of oppresses Maurice Sheni, it could be allowed, but if it does not follow, then if it doesn't follow what's required by the constitution, which is the primary rules, then it would not be a just law.
So which one is the primary rules?
What is stated in the Constitution of State of Shanimia.
Okay, so any law that is considered as the amendment of the constitution that goes against the principle of the constitution itself, which is the primary rules, will be considered as nullified, kan?
Yes.
Okay, in that manner, yes, you can do that. However, you are talking about constitution and the constitutional amendment. Siapa yang tinggi, siapa yang primary, siapa yang secondary, right? you have to be careful because we don't want to conflict the amendment. Okay. Kalau kita ambil macam ni lah kalau amendment, we are talking about amendment being the secondary rules. Boleh tak kita pakai secondary rules HAT punya rule of recognition, rule of education? Boleh tak kita pakai? Can you go along that line?
Okay, give me a moment, sir.
Siapa-siapa yang lain, kalau lah kata what Adin saying is that look at the constitution. Kalau constitution tu dah memang clear cut and then they are trying to amend it, and the amendment punya process is a process that being allowed by the constitution itself to amend the constitution, whether the amendment punya process is considered as secondary rules. Because amendment to the constitution must be made by certain process, by certain institution, right? I.e. the parliament have to be in sitting, the parliament have to have quorum, and then the process of tabling the amendment by virtue of a bill, and then it has to go through voting process or debate process and also on. Those are considered as the process. The process is reflected in law. Okay, the process is not simply created by human being. It must be supported by the existence of a law that allows that process to take place. So that particular process is linked to this law, which is considered as secondary rules. So kalau you boleh kupas to the extent, then you are going to be right. If
Sir?
you are, yeah.
Stop. Finish your ayat. Sorry, sir, for interrupting.
Macam mana?
Finish your sentence. I'm sorry for.
So in other words, itulah what I'm trying to say is that if you want to go along that line, you must be able to take the amendment process where it is being linked to a specific law, okay, and that specific law must conform to the secondary rules punya test. Dia punya rule of education, rule of recognition, dengan the other one apa ni? Aku lupa lah. Education.
Rules of change.
Rule of change. Okay. So if you can put that into argument and discuss the amendment punya law and the primary rules of constitution, then you are okay. The other way that you can do is you can put the amendment and the constitution as the primary rules. However, you want to look at the secondary rules. Secondary rules yang tak ada dekat sini. Okay, there is no existence of secondary rules because there is because dia cuma buat keluar command as primary rules. Dia tak ada pun mention kata okay, we have a set of law to take effect the amendment that is being made to the constitution. Maksudnya dia kena ada rule of education, recognition and yeah. Boleh nampak tak yang tu?
Sir, I have a question, sir. So maksudnya kalau kita nak guna yang amendment and constitution as a primary rules and kita nak claim yang secondary rule dalam question ni tak wujud, so therefore the monastery tu does not need to obey the law lah, sir, kan, because it does not comply with the principles of HAT tu.
Very good, very good. So kalau yang the first one tu nampak jawapan dia kepada okay, they have to follow, because kalau you tengok benda ni kalau pakai the first argument yang tadi constitution dengan amendment kan, nampak macam valid. Tapi yang kalau you pakai the second approach, dia kata there is no existence of secondary rules yet because this is just a new amendment, therefore dia akan kata it is not considered as law. The law is not valid towards HAT lah. Depend on how you argue. So di sini you boleh nampak your answer is subjective. Jangan takut. You must be able to present or argue that would support your logic, support your argument. So kalau you pakai the first one, jawapan dia pun akan berlawanan dengan the second one. you are going to be safe. You are going to be right. Because you are doing an analytical application of the problem towards the jurist idea. Guys, nampak ya?
Sorry, sir.
Yeah, soalan. Yes.
I don't understand regarding the first way. Meaning that maksudnya the constitution is recognized as the primary rule. The amendment made to the constitution, the process itself, it is recognized as the secondary rule. Is that right, sir?
Yes. Because kalau you tak boleh buat amendment to the constitution, kalau tak ada law that allows amendment to be done, how can you amend the constitution? Just because you rasa you are in power, you can amend it. There mesti ada provision in the constitution about the process that you have to go through in order for the amendment to be valid.
So, despite the fact that the process, the amendment to the constitution is inside the constitution itself, it is still considered as the secondary rule.
Yes. Why? Because primary rules is talking about command. Kan? The kalau you tengok hard, primary rules equals to command. You have to follow. Dia macam Austin juga. Tapi dia pecah kepada primary and secondary. Austin dia cuma satu je, command. I am the sovereign, I am validly in power, so you have no way of to choose whether you want to follow or not. No, you have to follow. Itu kalau Austin. Tapi kalau hak dia relax sikit. Dia orang kata lebih tumak ninah. Dia ada process that you have to go through in order for you to say whether the law is to be recognized of obedience. Whether you are going to obey or not, it depends on whether it fits in the primary and the secondary rules punya elements. Boleh nampak?
So, if we were to argue that way, maksudnya the Morastrian tu has the duty to obey the law lah kan, because it is a valid law.
Yes, it is. If it's valid, kalau you pakai the 3 rules of secondary, you analyze and you criticize and you argue, right? So you can make it as a valid law that they have no choice but to follow. Kalau kita tengok apartheid, the fact that they are changing the constitution and oppressing the blacks, yeah. So it is considered as valid. But people all over the world, kita sanction South Africa because we see it as unjust. But to them, as far as the validity of the law is valid. Why it is valid? You have your own argument lah. Kalau you pakai hak di situ dekat South Africa, then it might be seen as a valid law. You nak peduli apa? This is our country. This is the process that the constitution of ours is asking us to do. So I am following the constitution and the criteria of HAT when he says that rule of education, recognition, and so on is it can be identified clearly. So you have no way to say that our law is wrong. Kalau you dapat the first one, memang jawapan dia you have to follow. Kalau the second one, if you choose that as a mode of primary and secondary, then they don't have to follow the law. I mean the citizens of that country. We are not talking about international punya position. Kalau you ada yang dah buat international law lagi, you tangan tu gatal pula nak pergi discuss the international law punya perspektif, jangan. Okay. Ini dia limit you to constitutional law with the international law punya argument. Soalan? Ada soalan.
So,
yeah.
But because the question states that we are the lead counsel for the Morastrian plaintiffs, doesn't that mean our answer, even based on jurisprudence, although maybe initially it would be analytical and there's some sort of comparison, in conclusion, it still has to benefit the Morastrian juga lah kan, sir?
Tak juga, because you are in the court system, in the judiciary. You don't care about what happened to the government.
Okay.
The government can collapse. Yeah. So if you are in the judiciary later on, government of Malaysia collapse, you peduli apa? Because the structure, the institution is still standing. Kalau institution, the last institution that will go is the legal institution lah. Kalau lah kata the collapse of the country, kalau tak ada legal institution, then we are in the state of apa orang panggil stateless country. Okay, we can see a number of countries in the world, stateless country. Libya, apa Syria, kita ada apa nama country, I remember lah, several African countries. They don't have a government. They are fighting each other under civil war, where there is no existence of law. Whereby when you talk about law means the enforcement of law. Enforcement of laws, yang boleh buat enforcement of law is the judiciary. So kalau tak ada judiciary in that country, habis lah, the whole thing collapse. So it is a stateless punya country. So in this situation, the legal institution is still standing. So you can go to the extent of nullifying the the executive or the legislative. That is what your job pun, kan? Ingat you jangan favor pula dengan government. You favor by virtue of juris boleh. You jangan favor by virtue of you are being employed by the government, meaning your money, your apa gaji dapat daripada government, therefore you have loyalty is there. No, kita bukan loyal to the government. Kalau government jahat, kita kena kata government jahat lah.
Bukan sir, maksud saya sebab we're the lead counsel for the Morastrian, the one that is being oppressed.
Oh, I see. Yeah. I silap So you in that situation lagi lah, you are not bound by anything because kalau lead counsel of the Morastrian plaintiff, maksudnya it goes to court. So in the legislative lah, judiciary punya system masih intact. So tak ada problem lah. You tak ada apa kata bias kat situ because you are on the side of the plaintiff.
Okay, so when we answer the question, we have to make sure that the arguments benefit the Morastrian, kan sir?
Yes. So you takkan kata the law is valid, so as the lead counsel of Morastrian, you have to follow the law. You try your best to win your argument lah.
Okay, so meaning if we were to use Hart's punya argument, it is better for us to say that the secondary rule isn't fulfilled and it isn't valid, right?
Okay, good. Then I stand to be corrected lah. So you cannot, tapi you boleh present juga the argument of the other person that is going to utilize the same argument of Hart. So you boleh kata the lead counsel of the apa defendant lah kan? Pasal it's a civil case
Apa dia sir?
Pasal apa? Kalau dia pakai plaintiff, maksudnya it's a civil case.
Ya, itulah.
Jadi tak apa, whatever lah, you jangan go there lah, nanti you confuse So in other words, you pakai the second argument lah to win your argument, and you can state, you can argue saying that the first mode of application yang kata amendment dengan constitution tu sama, everything is okay, is going to be argued by the opposition. So you boleh kata the opposition argument in this case are going to be wrong because Hart is saying that the secondary rules must not be within the primary rules, which is the constitution. Ya, maksudnya kena ada statute yang lain, and then the role of judiciary in giving justice. So you boleh present dulu. Okay, you have to make sure your argument is more stronger than the other one.
Okay, sir. Understood. Thank you.
Thank you. Okay, right. Soalan lagi? Very good. Observation. Alisa tadi. Anis ke Alisa?
Aimi.
Right. Next, kalau kita tengok, so if we cannot make all the government based on the jurists agree with us, does it mean that for that conclusion we have to state that the best argument of jurists will support the plaintiff? Yalah, bahaya juga kan. So if you were to be in the position that your argument is going to lose your position or your party that you represent, memang bahaya. Okay, so out of 15 of them, in order for you to present, you are to be the plaintiff counsel kan. So kalau you nak plaintiff, always find a jurist that is going to side on you. So tak boleh sebarangan kita bawa masuk. Takut bawa masuk ya, actually kita commit harakiri. You are helping the argument of the defendant. Boleh guys?
Boleh sir.
So the next one kita nak tengok ialah kita pergi natural law. Natural law pula. Kita tengok natural law, siapa yang you nak cari tadi? Tengok. Natural law. Nak ambil John Stuart Mill. Okay, good. John Stuart Mill macam mana?
So can we try Rawls?
Okay. Mill tak mau. Kesian kat Norina.
Okay. Kita try Mills dulu.
Okay. Mills is very straightforward. Apa Mills kata? Guys, I extend sikit boleh ya? Minta permission, extend. Kita start pukul 9. Our lecture is 2 hours kan? So, is it possible for you to continue? Lambat jawab. My wife kata, lambat je jawab. Do you want to continue or what? You want to continue the next time? Hello?
Kalau habis pukul 10.30 se.
10.30, okay. I pukul 12 pun boleh. Tapi I takut lagi lagi bawa masuk dalam fact punya apa isu lah, itulah. No wonder student sekarang ni banyak complain. Okay, half an hour. Let's 50 minutes for Mills, 50 minutes for Rawls. Okay, 15 ni Mills macam mana dia punya principle or the theory that he is trying to portray? The law can or cannot? Macam mana Mills, guys? Cepat. Apa dia punya idea? Mills, what he is trying to say?
Mills' idea is on the harm principle.
Okay, good. Harm principle tu apa?
The harm principle states that the law can intrude in the individual's the law should only be limited to prevent harm to other individuals.
Yes, the law, you can utilize the law only to limit harm towards others, which is harm physically and the rights of that particular person. So kalau lah kata any law is the law must come in to protect. So can you apply this in this situation? Can the law deprive of a certain community to the extent that they are going to be punished of their rights over their properties and then banished and expelled from the country?
Yes, sir. There are direct harms towards these groups of people.
Very good. So di situ clear cut. Yeah, it is against the harm principle because the law that the Constitution Amendment ni telah akan dan sememangnya akan merosakkan dia orang punya position of rights in terms of their property, in terms of their life, in terms of their security as a citizen. So clear cut, you can utilize this to win your case. Boleh, guys? Nampak tak argument of Mills?
Boleh, sir.
So, you ambil Mills sebagai you punya defender. So, okay, any argument about Mills yang you rasa nak extend is quite straightforward actually, So, but you can lengthen the argument by putting in your example, legal example. So you can quote any law that is against the right of a person is once the court can say that it is nullified, the court nullified that particular law, then it's considered as in line with harm principle. For example, Tejempo. So you can quote Tejempo and saying that, look, in this particular situation, the law is valid. However, the law is going against certain principle of the right of a person to life, because under Firearm Act, he is just sentenced for 20 years, but because of the he was sentenced under emergency essential regulation, so he was sentenced to death. That is wrong. Okay, and the court says no two government can run within the same period of time. So you boleh win by quoting certain cases. Any cases of your relevance, any cases yang ada relevancy to your argument, you can bawa masuk. Boleh, guys? Anyone who wants to make a statement tadi?
Can I ask a question?
Yes.
Okay. Since Sir cakap that we have to give evidence, is it a must that when we cite this one jurist, we must cite the evidence like based on the cases, or like should we just like directly apply it? We give the theory from the jurist and then we apply the application terus, or do we have to actually like give one evidence? It's a must.
It's not a must, right? It is not a must. Tapi you nak markah banyak, right? Because you compare to the other person who is doing the same argument, right? You want to stand out to compare with that friend of yours who is actually using meals to win the argument, but you are able to come up with certain legal punya argument by virtue of statute ke, case law ke, then okay, you should be getting more marks as compared to the other person. Itu je yang I nak ketengahkan. It is not a must, but it is preferred, because you will get more marks as compared to the other person. Because kita dalam exam, bila I check scripts, kita nak tengok the one that is outstanding. The one that outstanding, kita kena bagi markah banyak lah, because the effort that was put into argument. Kalau you pergi court kan, you nak menang based on simple probability ataupun a sure punya probability. Obviously you want to go along the sure probability kan. You increase your probability by virtue of all the arguments that you put in. Legal argument, I'm saying legal argument, not jurisprudential argument. Tapi jangan sesat nanti lagi you go along the line of constitutional law punya argument pula. Always stick to the path. You pergi example and then patah balik to the jurist. Okay, guys, 10-8 minit. Sekarang kita pergi ni lah, apa tadi nak cakap tentang siapa yang nak tanya apa yang kita nak buat? Ross dia nak buat Ross. Macam mana Ross?
Sir, can I try?
Yes, please.
For Ross, because he has the theory of veil of ignorance, then the lawmakers must put themselves behind the veil of ignorance, where they must make laws unbiased of race or religion, and it will determine if that law is fair or not. Thus, the plaintiff can argue that the laws which deprive the particular religious community of monastery of their citizenship and want to expropriate and seize all properties owned only by Morastrians without any compensation, and also to banish and expel all Morastrians from the country within a period of 1 year would be an unjust law.
Okay, your unjust punya statement because of the fact that kita Ross ada mention about what is the principle of Ross?
Veil of ignorance.
Veil of ignorance ada kena mengena dengan original position kan?
Yes.
You have to ingat the rest of you, kalau you nak kata you nak pakai Ross, you kena ada original position, veil of ignorance, veil of So you have to elaborate what is veil of ignorance. Nobody knows that the position that they are in is, nobody queries the position that they are in. When they were born with that particular status. So tak boleh lah, yeah. So this veil of ignorance have to be removed. Then once we uplift the veil, bila kita singkap benda tu, kita akan nampak the original position that we have to achieve. Because everyone wants to go forward. So if the society in the problem of the question, the government, the nationalist party, who command 2/3 of the country, must be able to look at the situation. Meaning, they are to bring everyone forward. They cannot suppress and deprive other people from their rights. If they were to do so, the country would not move forward, obviously. Okay, when there is apa orang kata kepincangan, the problems that is not settled within the countries, it would not be a move forward. It would be a move backward, because you raise the risk of risk of fighting over one another. Because people are not going to just accept the ruling that your house is being taken away, you are to move out from the country. Nobody is going to take things lightly. And they all akan ada resistance. So once the resistance is there, that's the end of the beginning of the end.
Sir, so for clarity, that means when I explain roles, firstly, okay, I mentioned theory of veil of ignorance, then I have to make it clearer that we have to lift the veil to look at original position.
Yes, and then if you look at the original position, then you realize that the law that they create is not justified. Where you say the society is going to be divided, and then the society cannot move forward as a country, member of a citizen of the country, the probability of chaos could happen. Therefore, we have to stop this.
Okay, sir. Thank you.
Then, therefore, you win your argument lah. Boleh ya?
Boleh, sir.
The rest macam mana? Dia. Okay. Okay, good. Alright, so I think we have covered 4 orang dah. So yeah, so you want to continue or we end the session? Or you have any other question that you want to ask? Saya kan 4 orang tu kita dah cover dah.
Saya ada soalan tapi macam awal sangat. Nanti time final ada word limit ke?
Okay. That is a good question. Kalau when it comes to open book, and so you can write anything, obviously, right? So kalau you kata tadi you nak ambil Jeremy Bentham as your argument, so you mention about him, you mention about his idea, you mention about some legal example of his idea that makes sense in our legal environment. Then habislah, itu yang 3 je elemen on A, the A part. The B part pula, how long you are going to argue. Bila you perah santan tu, you tak boleh perah dah. There will be a limit. You tak boleh nak perah lagi dah. You nak goreng. Kalau you goreng lagi, maksudnya santan tu dah cair. You get what I'm trying to say? Meaning that I cannot be telling you a certain number of words sahaja is going to be accepted. No. Tapi kalau lah kata the examination punya orang kata instruction, dia dah bagi dah certain numbers, then you limit to the certain numbers lah. For me, I would say I'm not fussy about that. I just want to look at your argument. If your argument makes sense, it is a bit lengthy in nature, still tak merepek, tak mengarut, tak out of the answer, then should be acceptable.
Faham, sir. Thank you.
Okay. Any other question before we last one? Ada. Tak ada. Okay. So kalau tak ada, thank you so much guys. I'll be passing the record to you later on, insyaAllah. Thank you for coming to class. All of you, Chinese. Thank you. Assalamualaikum. Good night.
Thank you, sir. Assalamualaikum.
Salam. So everyone has to sign off in order for me to end the recording. Ni dengan Nurul Syafarah. Nurul? Alright.